Courtroom 2, please read your chat.
We're responding.
Good morning, everyone.
Good morning, Judge.
I'm gonna try to sound more excited, but I'm gonna say happy Friday anyway. For
Good
some
morning,
of-
Judge.
Good morning.
Oh,
Some of us that won't be working tomorrow, right?
pretty good. Yeah, excellent.
Okay. The inmates have to sit over here in this chair.
Okay.
All right, ready to start. Good morning, Mr. Walker.
Good morning, Your Honor.
How are you?
I'm doing great.
I thought you all were coming in to be with me today.
No, not today. Maybe after the new year.
Maybe in the new year, okay. And I see a new ASG, do I?
Good morning, Your Honor.
Morning, how are you?
I'm doing well.
And
How
it's
are you doing?
good, Miss Dillingham.
Yes.
Okay, welcome aboard.
Thank you. Thank you very much.
You have any other new ASGs, Mr. Walker?
Yes, we have one additional one, Mr. Abdullah, but I don't see him on the line, so hopefully he's logging on.
Okay, gotcha.
I'm texting him as we speak.
Okay.
Good morning, Judge.
Good morning.
Whenever you're ready to start, we'll be starting with position 24, Thomas.
Okay. All right, I'll go ahead and get started. Good morning, everyone. I'm Judge Regina Mincy, and this is our state all-purpose, or as we call it, SAP calendar for Wednesday, December the 22nd, 2022. I want to first remind everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. So govern yourselves accordingly. I want to remind the defendants on this calendar that you have certain constitutional rights. The first being that you have a right to remain silent. Anything that you say about the facts, the circumstances, or the occurrence of your case can and will be held against you. Listen to your attorneys and follow their instructions. You also have the right to have an attorney or counsel to represent you at this point, and most all of you do. And you know who your attorneys are. So please let them do their jobs and listen to them. I don't have any other announcement. We'll try to move as quickly as we can, but please pack your patience and we will do our best to move through the calendar. Understand we're starting with position 24. Is that a negotiated plea?
Yes, Your Honor.
All right, and who do we have there?
Mike McLean representing Steve Thomas.
Okay, Mr. McLean. Okay. All right. And whose case is this, Mr. Walker?
I will be taking it for now, Your Honor. The state's recommendation is 12 months to serve, 60 days, credit for time served, 14 days, balance probated, with the conditions of a SDET course. and to comply with all martyr suspensions. No further contact with the victim, whose first name is spelled Horija. Last name is spelled Joof.
Okay. All right. I think I forgot to say this. This is case number 22 CR 008216C. And this is one charge of PI or public indecency. The offense date is 11/11/2022. Mr. McLean, is that your understanding of the plea offer?
It is our understanding, Your Honor.
All right. And your client is ready to take a plea this morning.
That is correct.
And let me ask a tough question. Where is our plea paperwork? Have you sent it? Have not? Because Ms. Champion is going to be sitting here with a interesting look on her face if she doesn't have it by the end of the calendar.
Your Honor, we will be able to send it by email. We do have a machine here which does the cell scanning, but I'll have to impose upon Deputy Norris to have me log on so I can forward it once it's scanned in as an email to myself.
Okay, that is good, making sure we have that because it will hold her up. She has to wait a long time for all of the plea paperwork today. So we appreciate you guys helping us to get that in, okay?
Right, yeah, he's already signed it.
Okay.
The statement, the plea and verdict form, and the contact information sheet, which we will send separately to probation.
Great. All right, Mr. Thomas. Good morning. I understand that you're willing to take a plea today.
Yes, ma'am.
All right, in order to accept your plea, I have to ask you a series of questions to make sure that you understand what you're doing and that your plea is voluntarily and free, and that you understand the gravity of what you're doing today, okay?
Yes, ma'am.
First of all, I want you to raise your right hand for me. I'm going to swear you in. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, you put your hand down. First question I need to ask you is, are you under the influence of any medication, drugs, or alcohol at this time?
No.
Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
Do you understand that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes.
Do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And do you understand that, let me back up. Are you prepared to agree to waive these rights today?
Yes.
Has anyone told you that you would receive a lesser sentence for pleading guilty today?
No.
Has anyone promised you anything to plead guilty?
No.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
And as to the charge of public indecency, how do you plead?
Yes.
I'm sorry?
Yes.
You have to speak up to the court.
I said,
We
yeah.
got microphones here.
Right. I didn't hear you. As to the charge of public indecency, how do you plead?
Guilty.
Okay, all right, and you heard the offer and the conditions by the state. That's 12 months to serve 60 days. And you're getting credit for a time served of 14 days. The balance will be probated. You have to do a SDET, which is an evaluation. You're going to also be on full term of your probation, which is 12 months, and you're to comply with all MARTA suspensions. So check with your attorney to find out what that suspension time period is and comply with it, or else you'll find yourself right back here again. And you're also to have no further contact with the victim in this case. And I believe it's Horija or Horija Joof, J-O-F. So you can comply with those terms, correct?
Yes.
Okay, all right, I will accept your guilty plea, and that will conclude our business for today. Do you have any questions about your conditions or anything?
No, ma'am.
All right, good luck to you.
We have position 14 next, Judge.
Okay. And that is a negotiated plea.
One second, Judge, I believe so.
It is.
Judge.
Price. Don't have a seat on the phone.
Are we ready to go on position 14, Judge?
Now I am. I see him coming to the chair. Is that position 14 or, oh, this is position 14. I'm sorry.
I think he's on the jail court iPhone, Judge.
Yes, that's correct.
I'm sorry.
He's on the jail court's iPhone on Zoom.
I see that. I'm sorry. I was thinking he was a different case. Thank you for making me aware. I apologize. This is case number 22 CR 0076788. Bernard Mitchell. Is that you, Mr. Mitchell?
Yes, ma'am.
Okay, good. You're charged with SB. That offense date is 11/7/2022. And you're represented by Mr.
Angela Dotis with the Public Defender's Office.
That's right. Angela, tell me the last name again.
Dotis, Dodys.
Notice, right. All right, and then again, this is a negotiated plea. Ms. Dillingham, you're going to be handling this one?
Yes, Your Honor. Today we are recommending 12 months to serve 92 days, credit for time served 46 days, balance probated with the SDET recommendation. Your Honor, this case occurred while the defendant was incarcerated for another crime. A detention officer by the name of Carmelia C. was bending over distributing medications when the defendant came behind her and smacked her behind. So for that reason, we are asking for a stay away for a no further contact with Officer Carmelia C.
All right. All right, Mr. Dotis, is that what you understand the plea to be?
Yes, Judge, and I went over the case as well as the offer with my client yesterday. He has agreed to the offer and we stipulate to the factual basis, venue, and ID for the purposes of the plea.
All right, thank you very much. All right, Mr. Mitchell, can you hear me?
Yeah, ma'am.
All right, can you raise your right hand a little bit for me? I can kind of see there. Need to swear you in. You affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you put your hand down. Are you under the influence of any medication, drugs, or alcohol at this time?
No.
Are you satisfied with the services and representation of your attorney? Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
But they said too much then, though. I ain't do all that.
Excuse me?
Mr.
Yeah,
Mitchell,
ma'am.
I would advise you to stop talking.
Right. I just need you to answer these questions, yes or no, okay? So do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
Do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And are you prepared and agree to waive these rights today?
Yes.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
Yes.
Have they told you that if you pled guilty, you would get a lesser sentence?
No.
Okay. Has anyone promised you anything just to plead guilty?
No.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
So as to the charge of SB, how do you plead?
Yes.
How do you plead, guilty or not guilty?
Guilty.
Okay, all right. And I will accept your plea as negotiated. You'll be on probation for 12 months. That was to serve 92 days, but you're being given credit for time served at 46 days, balance probated. You're to get an SDET evaluation and have no further contact with Officer C. Do you understand that?
Yes.
All right. Good luck to you. Thank you.
All right.
Position 4 favors.
This is case number 20 CR 002679D. Raphael favors. You're charged with 1 count of criminal trespass. The offense date is 3/18/2020. And again, who's is this from Dillingham or? All right, ASG.
Yes, Your
Dillingham.
Honor.
All right, go ahead. You may proceed with the plea offer.
Yes, Your Honor. In this case, we are recommending 12 months to serve 106 days, credit for time served 53 days, balance suspended. This was a criminal trespass case at the location 2500 Center Street. So for that reason, we are asking for a stay away order from that location, as well as no drugs, alcohol, or firearms.
Okay, now is this a plea or is this an arraignment? I think I may have misstated. My calendar says arraignment, but I'm not sure.
Yes, Judge, this will be an arraignment and I submitted my waiver last night.
Okay, you did your waiver, okay. All right, so I am going to only do an arraignment. This is not going to be a plea. All right, and so Mr. Favors, can you hear me?
Yes, ma'am.
And you waive your attorney waived formal reading of the accusation. So you know that you're charged with 1 count of criminal trespass. and you're formally being accused of this crime by the Solicitor General's Office of Fulton County, and this charge carries a maximum sentence of 1 year in jail or a maximum fine of $1,000. This case will be reset for jury trial, and that trial will be scheduled by the state court judge to whom this case is assigned, or the division judge, at further notice for trial. Make sure that we have your updated address and phone number, that your attorney has that as well if it changes. At the jury trial, you have the right to an attorney as you do now. You do not have the burden to prove the charge at trial. The state, represented by the Solicitor General, will bear that burden and will have to convince the jury beyond a reasonable doubt in order to get a conviction in this case. If they do get a conviction, you could face again a sentence of up to 1 year in prison or a fine of $1,000 for the charge, and that could run. Well, you only have one charge.
Two charges, Your Honor.
Is it two?
Criminal trespass and obstruction.
Oh, are there two charges?
I think there should also be an obstruction charge, Judge, but we were gonna do that.
Okay. I only have one on my calendar. So there's a second charge, obstruction of a law enforcement officer. So there are two charges, and each of them would carry that maximum fine and the penalty of $1,000 or 1 year in prison. They could run concurrently or consecutively. So based upon this information, do you plead not guilty to these charges?
Yes, ma'am.
All right, I accept your plea of not guilty. Your case has been arraigned and you will be further noticed for trial by the judge, okay?
Yes, ma'am.
All right, thank you.
We have position 19, Mr. Reese.
Your Honor, this is one count of interference with government property. Misdemeanor level.
All right. And this is a negotiated plea, 22 CR 008212A. Offense date 12/9/2022. Go ahead, state. Mr. Walker or Ms. Dillingham?
One moment, Your Honor. I believe Mr. Walker stepped out, but I can handle this one if you just give me.
I'm here. I'm sorry, Your Honor. I was on the phone with Mr. Howard. What position is this?
This is position 18.
Okay. Was it?
I'm sorry, 19. I'm sorry.
Okay, 1 second. Is it negotiated plea?
It is.
Okay.
And this is 22 CR 008269E. Jeffrey B. Reese, charged with one count of interference with government property, and that offense date is 11/28/2022.
That is correct, Your Honor. The state's recommendation is 12 months to serve 32 days, credit for time served 16 days. Balance suspended with the conditions of a stay away from 2727 East Point Street. That is all.
All right. And that must be obviously a government location.
Yeah, so we could say a stay away with the exception of any official business at that location.
And it says business or emergencies. Is that the
Yeah,
government office there?
That is the front door, the glass door to the East Point Police and Court Building.
Okay, to that building there. Okay.
Yeah, it's actually East Point Street, East Point, Georgia.
So unless he has court or any business that he needs to conduct there, he will be staying away otherwise.
Correct.
All right. That's everyone's understanding. We'll go ahead and take the plea. Mr. Reese, are you ready to take a plea in this case?
Yeah.
Can you hear me?
Yes.
Mr. Reese, can you hear me?
Yes, I hear you.
Okay. Raise your right hand for me, or at least I'm going to put you under oath. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay, put your hand down. Are you presently under the influence of any medication, drugs, or alcohol?
No.
Are you satisfied with the services and representation of your attorney?
Attorney, yeah.
All right, do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes.
And that you're waiving or giving up the right to trial by judge or jury, whichever you prefer?
Yes.
Are you prepared and agree to waive these rights today?
Yes.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No.
Okay. Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, your probation may be revoked because of this guilty plea today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
I will accept your plea as negotiated, and you understand the conditions. 12 months to serve 32 days, credit for time served is 16 days, and your probation, the balance will be suspended, but you need to stay away from that 2727 East Point Street, which is the police building, except for any lawful business or emergencies. Otherwise, you should not go there, okay?
Okay.
You understand that?
Yes, ma'am.
All right. So good luck to you.
Thank you, Your Honor.
All right, thank you.
Position 16, Moody.
Okay.
Your Honor, we are needing to speak to Mr. Moody further. If we could skip that and put him towards the end, it may be a reset. It is not a time served offer, and it might be a reset for a half a week or a week.
Okay.
Sit over here. Position 28, Woods.
Okay.
That is a negotiated plea on 28 Darius Woods.
Okay. This is 22 CR 008204Y, one count of terroristic threats and acts. The offense date is 12/8/2022. State.
Yes, Your Honor, the state's recommendation is 12 months to serve 28 days, credit for time served 14 days, balance probated with conditions of alcohol and drug evaluation, any necessary treatment, 6 weeks anger management, no further contact with the victim, Monica Dawson, and a stay away from 2900 Camp Creek Parkway,
Okay.
apartment U5.
All right. Is that your understanding, Mr. McLean?
It is, Your Honor. He has filled out the paperwork with me, and we will be sending that on to the JCS for the contact information and to the court for the plea paperwork.
All right. Mr. Woods, I am ready to take your plea. I'm going to swear you in. Can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down for me. And the first question I'll ask you is, are you under the influence of any medication, drugs, or alcohol at this time?
No.
Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
that you're giving up and waiving the right to remain silent and not testify against yourself,
Yes.
that you're giving up and waiving the right to trial by judge or jury, whichever you prefer.
Yes.
Are you prepared and agree to waive these rights today?
Yes.
Has anyone told you that you would receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, your probation may be revoked by a guilty plea here today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
And as to the charge of terroristic threats and acts, how do you plead?
Yes.
All right, 12 months to serve 28 days, credit the time served at 14 days, your balance will be probated. And while you're on probation, you need to get an ADET evaluation, take a 6-week anger management course, and you're to stay away from 2900 Camp Creek Parkway, apartment U5, and you're to have no further contact with Monica Dawson. Do you understand those conditions?
Yes.
All right. Good luck to you.
Sorry. Yes, thank you.
Can we do position number 3? Antonio Cruz.
All right.
Mr. Cruz, what, you have a question for me, the judge?
For you, I would like to talk to my attorney real quick. If they're all right with you.
Let's see how we can make that happen.
I just need like 1 minute.
Mr. Dotis, I don't know, do you all have a phone to call him there?
I don't have a phone up here. This, I don't have a cord to the phone up here. For North.
All right. All right, Judge, I'm gonna go up and speak to him if we could come back, Mr. Cruz.
Okay.
Thank you, Judge.
All right, thank you. We'll hold.
Okay.
Well, can we do position number 12? He's, David Mathis, he's a conflict.
Okay. And this is going to be a plea, Mr. McLean?
No, Your Honor. Ms. McLeod?
Position 12?
That's Ms. McLeod, okay.
Oh, Miss McLeod. There she goes.
Yes, Your Honor. Good morning.
How are you?
I'm well. Thank you for asking.
Good. All right, we're on position 12, David Matthews. That
Yes,
is
Your Honor.
case number 22CR008239E. He's charged with 1 count of battery family violence, the 2nd count of cruelty to children in the 3rd degree, and a 3rd count of calls or otherwise contacts 911 and fails to hang up, disengage the connection for the purpose of interfering. All of those 3 offenses occurred on May the 22nd, 2022. State?
Yes, Your Honor. The state is recommending 12 months to serve 90 days, credit for time served 13 days. We are also recommending a family intervention program, a stay away order from the victim, Brandy Gillespie, and third party third-party contact for their children, Your Honor. In this case, the defendant became very violent and hostile with the victim, Miss Gillespie, who is the mother of his child. He choked her until she could not breathe and punched her in the right eye. So for those reasons, we are asking for the stay away and the no further contact.
All right, and give me that stay away address again.
It's 5474 Industrial Boulevard.
Is this a plea, Your Honor? And this is a plea, correct?
It is not a plea, Your Honor.
Oh, it's an arraignment.
That is correct, Your Honor.
Gotcha. Okay, I'm sorry.
The alleged victim is on the line, Your Honor. She has been in contact with the prosecutor's office more than once. She's gone down there and signed an affidavit, which is a part of the record in this case, stating that she does not want to go forward and she is not going to be the state's witness in this matter. And she's on the line, Your Honor.
All right.
She had stated at his first appearance, Your Honor, and I had raised with the court the issue of the charges concerning the cruelty to children. There were no children present at the time, and that was her testimony when she appeared, Your Honor.
All right. This is an arraignment, Miss Gillespie. That's correct.
That is.
And generally, with an arraignment, I don't necessarily have the victim to testify. I do understand your position. ASG Walker is on the line, and they obviously have your contact information and can get back in touch with you when they need to. But I am here today to only arraign the case and formally charge Mr. Matthews with the allegations that are in the accusation. So this is not your trial. This is not a hearing for that matter. And so I don't believe, again, that I'm going to need you to speak or address the court if I'm only doing an arraignment today.
Well, Your Honor, I would like to raise the issue of his bond against me because I do believe that his bond is too high because it includes provisions for the cruelty to children. And there were no children present when this alleged incident took place.
And how much is the bond at present?
I believe it's $8,000, Your Honor. It's an $8,000 good bond. That's my recollection. That's what's in my notes.
Yes, I have it now. So it's $5,000 on the first charge, $500 on the second, and $2,500 on the third.
Yes, Your Honor.
All right. If we're doing let me arraign him. I'm going to do a bond. Have you filed the bond modification motion?
No, Your Honor, I haven't filed it yet.
Okay. All right, we'll do
I just
that.
filed for speedy trial for him.
Okay, so for speedy trial, all right. And since I was the one that entered this, since I was the one that ordered the bond back on December 12th, I will hear that matter as well, and then I will let you address the court, Ms. Gillespie. Hold on one second. So Mr. Matthews, I'm going to formally arraign you and make sure that you understand the charges that are against you. And so I want you to know that you've been charged with 3 charges. And I do understand that your attorney is telling us that there were no children present, so they don't understand the cruelty charge. And I'm going to ask that you speak to the Solicitor General the Assistant Solicitor General handling this matter to discuss that charge, whether they will go ahead and dismiss it. But I will arraign you on what has been formally accused. You have been charged again with those 3 charges: the battery, family violence, cruelty to children in the third, and then interfering with 911 calls. And again, each of those charges carries, and they've been formally accused by the Solicitor General's office in Fulton County. Each of those charges carries a maximum sentence of 1 year in jail or a maximum fine of $1,000 for each of the charges. This case is going to be reset for a jury trial, and that trial will be scheduled by the state court judge to whom the case is assigned as further notice for trial. Make sure that you keep your address and phone number and contact information current with your attorney as well as with the court, so that you will get those future court dates. And at the jury trial, you will have the right to an attorney, which you have now. You do not have the burden to prove the charge at trial. The state, represented by the Solicitor General's office, will bear that burden and will have to convince the jury beyond a reasonable doubt in order to get a conviction in this case. If they do get a conviction, you could face a sentence of up to 1 year in prison or a fine of $1,000 for each of those charges, and it could run concurrently or consecutively. Based on this information, how do you plead to the 3 charges: battery, cruelty, and 911 call interference?
Not guilty.
All right, we'll accept your not guilty plea. This case will be reset for jury trial before they're noticed by the court. Now, as far as the bond, Ms. McLeod.
Yes, Your Honor, the bond is unreasonably high because it includes provisions for charges which should not have been a part of this accusation, Your Honor. There were no children present when this alleged incident happened. And part of the bond is cruelty to children. Also, there was nothing about it, even though there is a charge for interference in a 911 call, based on what the alleged victim stated, that did not happen. I recall that her testimony was that she had left her cell phone in his vehicle, not that he had taken the cell phone at all.
All right, that will be a good segue into me hearing from Ms. Gillespie briefly. Mr. Gillespie, raise your right hand. I'm going to swear you in. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. And so what would you like to tell me about this case? I think that was a good idea, but go ahead.
That what they're stating happened didn't happen. I have said this numerous of times. He did not take my phone from me. I had left my purse in the car with him, and we were in the house, so he did not take my phone. He did not strike me. We just had a disagreement. So I don't understand where they're getting all this stuff from. That he struck me, that he choked me. There was no children present when me and him were having a disagreement. He did not stop me from calling 911. He did not stop the neighbor, take their phone, anything like that. So I wish that this case would just be thrown out.
Okay. I'm not necessarily at liberty at the moment to do that. The case has been formally arraigned, and I have heard your testimony, and Mr. Matthews' attorney has asked for a bond reduction. And since the second charge anyway, the cruelty to children, that's the smallest amount, which is $500. Then the hindering of 911 calls is $2,500. So I will reduce the bond to
Your Honor, before we reduce the bond, would you like to hear from the state?
I would. I'm so sorry. I did not mean to leave you out. Thank you.
Thank you. And
go ahead.
Can I ask the victim a couple questions since she testified?
Yes, you can cross-examine her. I apologize.
Hi, Ms. Gillespie. So the information that you told the officer, which is in the warrant, is that incorrect? Did he not prevent you from calling 911? Was there
No.
not a 2-year-old present?
No,
Okay, so were you lying then or are you lying now?
I don't understand where he got that information from.
From you?
Oh, no, there was,
So were
he
you
did
being
not.
dishonest then or now? Because according to the warrant, you told him that your 2-year-old child was present and that only did he snatch your phone, he also stole your handgun. Do you not recall that?
I left my bag in his car. No, I do not recall telling him that.
Okay, nothing further for the witness, Your Honor. I would add to that pretrial reads the history.
I don't have a history on this defendant.
Okay, Ms. Dillingham, do you have the history on this? And while Ms. Dillingham locates the history, this is the purpose that we have warrants. It's not untypical for victims to recant and to change their story. But no question on the date of the incident, the victim told the officer that she was beaten by the defendant. He snatched the phone out of her hand. Their 2-year-old child was present and he stole her handgun. So I would add that the bond is not reduced and that we go forward with the information that's within the 4 corners of the warrant. I understand that the victim is now singing a different tune, but we're going with the information that she presented to the officer who took out the warrant on the date in question. All the other issues are a matter for trial.
Well, she denies that she told the officer that.
Everything's on body cam, Ms. McLeod, so I would say this is an issue for trial. It's not untypical for victims to recant and change their story. And the fact that the story is a complete 180 is quite obvious.
Well, I don't think it is obvious, Mr.
I have a hard
Walker.
time believing that all of a sudden there's no child, no stealing of a phone, he never hit her. There was a complete opposite story that was told to the officer on the day in question.
Well, please be reminded, Mr. Walker, that she did not call the police.
That I never said she did.
Okay.
And further, Your Honor, we do have a prior arrest in 2015 for battery family violence, prior arrest for aggravated assault in 2021.
Arrests are not convictions, Ms. Dillingham.
That is correct.
Regardless, Ms. McLeod, it's still in his history.
And
I'm
I'll just
going to read that.
I'll just speak to the injuries. I'm showing the officer observed a bruised right eye. So unless the victim punched herself in the right eye, we're going forward with the information that's on the warrant. And that's per the officer's own report. So I would ask that the bond is not reduced. There's been no change in circumstance. I understand that the victim is now recanting, but we all are familiar with the cycles of violence. And we're going forward with the information that was presented on the warrant that is a signed affidavit. Also, as I'm reading the warrants, actually her father is the one who notified neighbors to call the police. So her father was on the scene as well.
That is also inaccurate.
I have a hard time believing that her father and the neighbors both concluded against the defendant.
And my dad is
That
here.
was not her testimony.
Right.
I understand that's not her testimony. I'm just letting you know what's said in the warrant. So again, I have a hard time believing that her father and the neighbors made some conspiracy theory and the victim had a black eye when police arrived. So we're going forward with the information that's on the warrant.
May I speak? I can't hear.
Go ahead, Ms. Gillespie.
I did not have a black eye. And my dad, if you would like to speak to him, he's available. As I mentioned, he has dementia and David is his caregiver.
Well, I'm certainly not going to have him to testify if he has dementia, because that means that his memory is lacking if that's what his diagnosis is. I know they can have good days and bad days, but this again is not the trial. Okay, so those are all issues and things that your attorney knows that will be brought up and brought in at the trial. I am just trying to determine the issue of a bond reduction at this point and whether it is warranted. I understand I issued that on December the 12th. Today is December 22nd. I don't feel, given the circumstances of the case, that it is too high. However, I'm only hearing 2 or 3 cycles. Is that correct, ASG Dillingham?
Your Honor, we have 18 cycles listed. 3 of them were the ones that I mentioned, the battery, family violence, and aggravated assault.
Okay, so you have 18 cycles. Do you have any convictions at all?
Not showing any convictions, Your Honor.
Okay. And the parties do have a 2-year-old child together?
I'm not sure if it's together. Per the warrant said her 2-year-old child was present.
Okay, I'm sorry, Ms. Gillespie, is this the defendant's child?
Yes.
Okay. And you all were residing together and the child lives with the 2 of you, correct?
Yes.
So where was the child if the child was not there? You're on mute.
Your Honor, the alleged incident took place in the parking lot, that's my understanding.
Oh, so it was not at the home?
That is my understanding.
That is correct.
The parking lot of where you live or a parking lot of a business?
The parking lot of where we live, me and him live.
Okay. Well, again, these are issues that will need to be resolved or brought up for trial. This is not a trial at this time. I'm going, obviously, as Mr. Walker says, on the 4 corners of the warrant. I've been read some of the statements from the police report, the incident report, and the only thing that I will do at this point is I will reduce the bond to $7,500, and I will allow that. So the modified or the reduced bond will be $7,500 instead of the $8,000.
Good morning, Your Honor.
And so what I'm going to do again is that the first charge would be the $5,000 for the battery. And then on the cruelty, that can be a, I guess we can change that to either a signature bond or waive the, I'll just change it to a signature bond through jail on the cruelty, and then the $2,500 will remain on the third charge, which is the 911 calls. I'll just do it that way.
So it will be, still be a $8,000 bond, but it would just be 500 sure, signature bond.
500 signature. So it'll be split bond. I probably said that wrong, Mr. Walker. I'm gonna keep it at that amount, but it'd be a split bond. And the second charge of the cruelty, that would be a signature bond through the jail on that.
Okay.
Okay. I think I said that incorrectly at first.
Ms. McLeod can send me the bond order, the modified bond order.
Say that again, Ms.
Ms. McLeod, send me the modified bond.
Oh, Ms. McLeod, Ms. Champion asked for you to send her the modified bond order to April.Champion.
Yes, Your Honor.
Okay. All right, that will conclude this matter.
Pardon me, Your Honor.
I'm sorry.
This is JCS probation. I believe the court's request a probation officer.
That's for another case,
Another
officer.
case?
I'm sorry.
Okay. Thank you very much. I appreciate it. Sorry
Thank you
about
for thank you for making me aware that you're here. We'll get to you in a second.
Thank you, Your Honor.
Yes. I don't know, Mr. Matthews, if your attorney is going to want you to say anything, unless you have a general question.
Is this in regard to your bond, Mr. Matthews?
Yes, ma'am, and
Okay.
just to notify them that the other case that I had, that case was dismissed against me.
Not for sure what case you're talking about.
There
but-
was an aggravated assault that was dismissed. We're aware.
Aggravated assault charge. And the family.
That's correct. We're aware.
But that, I don't think that was one of the ones that she read, right?
I believe that she said it was an arrest, but not a conviction.
Yes.
But he is correct. The aggravated assault was a dismissal. So
Okay.
she did state it was not a conviction.
All right, but based on your overall history of 18 cycles, no convictions.
He actually does have a conviction in 2015 for robbery and simple battery family violence, but the state is fine with the $7,500 surety bond.
Okay. But I'm gonna leave it split the way I have it. Ms. McLean and Mr. Matthews with the 7,500 surety and then the 500 signature through the jail. All right.
Thank you.
All right, this will conclude this matter. We'll move on. Thank you.
We have position 11, Mr. Mack.
Okay.
What attorney is handling that?
That's me. My attorney.
Oh, you're up there. Okay, very good. Thank you.
Mr. Dotis.
What's the announcement on the case? It says hold.
It says hold for announcement. What are we doing?
Yes, Judge. This is going to be a negotiated plea.
Okay. This is case number 22 CR 008306J, John Henry Mack Jr., charged with 1 count of cruelty to animals and 2 counts of cruelty to animals. The second one being dog at large. Both offenses occurred on July the 8th, 2021. State?
Yes, Your Honor. This defendant has a history of cruelty to animals. We have about 3 warnings from ACOSC that was delivered to him for inadequate water, shelter, and unsanitary conditions for animals. This defendant does have quite a violent history. He is currently being held for murder. So for those reasons, we are asking for 12 months to serve, 45 days. And further, Your Honor, we are also requesting no further contact with animals due to his violent history with dogs.
Okay, so the, make sure I understand the plea offer and the plea, that is 12 months, 365 days and credit for 208 days. Is that
Judge,
correct?
Judge,
Yeah.
we actually we had some issues with that original offer, and we reached out, and so the updated offer, to my understanding, is 12 months, serve 45 days, balance suspended, and then the condition of no dogs.
That's correct.
Okay.
So how much credit for the time?
So,
served?
yeah, I was going to say, what's the credit?
He didn't serve any time for this specific charge, Your Honor. So we're asking for him to serve 45 days in relation to this matter.
So 12 months probation to serve 45 days. Balance suspended and no dogs.
Yes,
This charge isn't bad.
This charge is what now?
Not holding him.
That is correct. So he'll have to be booked in on this charge and then serve about 22 to 23 days, then the balance will be suspended.
Okay.
And of course, that's with the 2-for-1 calculation.
Mm-hmm. All right, if all minds are clear on that, then that's the plea that I will accept. And so, Mr. Mack, you're ready to take your plea?
Yes, Your Honor.
All right, do you stipulate to the venue, identity, and factual basis, Mr. Dotis?
We do, Your Honor.
All right, Mr. Henry, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, put your hand down. Are you under the influence of any medication, drugs, or alcohol at this time?
No, Your Honor.
Are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, Your Honor.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yeah, I do, Your Honor.
And are you prepared and agree to waive these? Ooh, excuse me. Are you prepared and agree to waive these rights today?
Yes, Your Honor.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, Your Honor.
Has anyone promised you anything to plead guilty?
No, Your Honor.
And do you understand that if you're currently on probation, that your probation may be revoked because of your guilty plea here today?
He didn't hear you. Oh, yes, Your Honor. Yes, Your Honor, I do understand.
All right, and do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, Your Honor.
All right, I will accept your negotiated plea. And you understand the terms that you will have to serve approximately 45 days. And then you will be on probation after that.
There's no probation, Your Honor.
I'm sorry, it's suspended. I apologize, it's suspended. But you are, the condition is that you will not own any dogs for the remaining time of the 12 months, even though you won't be on, won't be reporting or anything.
Yes, Your Honor.
All right, if you're clear on that and your attorney's clear, then I will accept that plea. And so that's it. So we're done. Thank you.
Thank you, sir.
Position 18, Mr. Price. The mask over your nose. Where's Mr. Price? Ms. McLeod? Well, evidently.
Morning, Your Honor.
All right, good morning again. This is position 18, Vincent Price, 22 CR 008212A. Mr. Price is charged with 1 count of criminal trespass. That offense date is 12/9/2022. State, this is Mr. Abdullah.
Good morning, Your Honor.
Morning, welcome aboard.
Thank you. Thank you. Sorry for my tardiness.
Oh,
At this time, the state is recommending 12 months to serve, 28 days, credit for time served, 14 days, balance suspended, and a stay away from 1180 Virginia Avenue, as well as no further contact with the general manager there, Octavius Brown.
okay.
What's the announcement on the case?
Right, and then the note stated, oh, for position 18 was the conflict.
It's Miss McLeod case, so will this be a plea or is she doing an arraignment?
Yes, which one?
This is my case, Your Honor.
Yes, Ms. McLeod, are you doing an arraignment or a plea?
This is a plea, Your Honor.
Okay.
It's a negotiated plea. My client is accepting the state's offer at this time, and the offer is accurate as stated by ASG Abdullah.
Okay. All right. Mr. Price, are you ready to take your plea?
Yes, ma'am.
All right. And Ms. McLeod, do you stipulate to the venue, identity, and factual basis?
I do, Your Honor.
All right. Raise your right hand for me, Mr. Price. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. Going to ask you a series of questions. Are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And are you prepared and agree to waive these rights today?
Yes.
And has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
No.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you, or the charge against you? I'm sorry?
Yes, sir.
Okay. All right. So I will accept your negotiated plea to the terms as we stated. Do you understand the conditions?
Yes.
Okay. All right. If you don't have any questions and all minds are clear, I'll accept your guilty plea. Thank you. Good luck to you. And remember those conditions of the stay away and no further contact. All right.
Thank you, Your Honor. This concludes my business before the court today. May I be excused?
Yes, you may. Thank you very much. Have a good holiday if I don't see you again.
Same to you, Judge.
All right.
Can we go back to position number 3, Cruz?
Okay. This is Antonio Cruz.
Yes.
Okay. Case number 21 CR 006094Y. And what is the disposition here?
Yes, Judge. After speaking with my clients, we're not going to go forward with the negotiated plea. And so we're going to waive our arraignment and go forward to jury trial.
Okay.
And I'll submit that as soon as I can.
All right, the waiver of arraignment, that is fine. All right, you can formally arraign Mr. Cruz in charge of the simple battery family violence. You'll be further noticed and be set for trial. All right?
All right.
All right. That will conclude case number 3.
Position 6, Mr. Hall.
This is 22 CR 008307A. Is it Kentrell Hall? Charge at 1 count of operation of an unregistered vehicle, 2nd count giving a false name, 3rd count driving without a valid license, and 4th count of failure to obey traffic signs, signals, and markings, all with the offense date of August the 30th, 2022. State?
Yes, Your Honor, we are recommending 12 months to serve 206 days, credit for time served 103 days with the balance suspended, Your Honor.
All right. Is that your understanding? Oh, okay, Mr. Dodis of the plea offer.
Yes, Your Honor. I spoke with Mr. Hall, went over the offer and his case, and he does understand it and accept it, and we just stipulate to the factual basis, venue, and ID for the purposes of this plea.
Okay. All right, are we ready to take your plea, Mr. Hall?
Amen.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
And Mr. Dotis, do you stipulate to the venue, identity, and factual basis?
I do, Your Honor.
All right, first question is, I need to ask you, are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Amen.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Amen.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you are giving up the right to have a trial by judge or jury, whichever you prefer?
Yes, ma'am.
Are you prepared and agree to waive these rights today?
Yes, ma'am.
And has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
And has anyone promised you anything to plead guilty?
No, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
Do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
Okay. All right. So again, that's 12 months to serve 206 days and credit for time served at 103 days and balance suspended. All right. There's no other questions. Anything else from either counsel?
Nothing further, Your Honor, from the state.
All right, thank you. All right, that will conclude this case. Good luck to you, Mr. Hall.
Your Honor, we have position 23 here at the South End.
Okay. 23.
Yes, ma'am.
Judge, Mr. McLean stepped out to send off those pleas. We might need to do another position.
Position 21 then.
41, okay.
21. Yeah.
21,
21.
gotcha.
Could we do something between positions 3 and 14?
Oh, because those are still Mr. McLean's cases.
Okay, well, I also have position 29 and 30, Mr. Lynch, client.
We
could do that.
We can do that.
Okay.
And that's the case that probation is here for. I don't know if it's.
Oh, yeah, which case, Mr. Barnes?
It was 29 and 30.
Okay.
Jasmine Worthen's.
Yes, Judge. Just, I don't want to overly complicate this, but I was hoping maybe we could. Me and Mr. Walker have discussed a resolution that would resolve her 2 pending cases as well as the pending probation matters. I did have a long conversation with my client at the jail 2 days ago, and I expect that she would accept that resolution. But I was wondering if you would be willing to sort of, I'm not sure if we could do a breakout room and put the proposed resolution to the court before I sort of go over that one more time with my client, just because I don't know if it was if I understood the offer completely when I spoke to her last.
You want to go into a quick breakout, Mr. Walker? Mr.
Yeah, we can do that. We can include probation. This was a case reset from last week. She has 2 open cases, and then she's on 4 different probations, misdemeanor probation. So
is that 3 probations, Mr. Walker? I was only aware of Three.
It's four. So on one day, she took 2 pleas in the same day. So maybe that's what you're thinking of. But she has 4
Okay.
probations, I believe. But I'll double check that. But
But you-
nonetheless, it was recent from last week. So
Okay. Is it Mr. Jordan?
Yes, ma'am.
Mr. Jordan, can you put, do I need both? You want Ms. Harris and Mr. Barnes in there?
I don't whoever's handling it, I don't know.
Is it Mr. Barnes?
Yes, ma'am.
And I saw Ms. Harris come on camera too. Do you come as a package or are you separate?
From my understanding, Your Honor, it's just me right now.
Okay, and we'll get back to you, Ms. Harris. So Mr. Barnes, ASG Walker, PD Lynch, and myself, can you put us in a breakout, please? Mr. Jordan?
Yes, Judge.
Mr. Lynch wants to talk to his client for 2 seconds, and she's at the pretrial, not the South Annex. Do you all have a number? Do you have a number for them to call?
I don't have a current number, Judge. They moved from the South Annex to downtown, so I don't have the number to the downtown location.
All right. Is that someone up there with her?
Yeah, I see an
Looks
officer
like
in
it's
the
there,
background.
Deputy? Deputy? Can you hear me? From the South Annex, is there a number to call?
ma'am.
I'm sorry?
I'm putting it in the chat right now.
Okay.
Judge Minzy,
Yes.
this is Mr. Barnes. I apologize for interrupting. Ms. Harris, my colleague, she's also on also. I wasn't aware that she had logged in, so I apologize.
She'll get you for that. No, we
Yes,
didn't
she
mean to
will.
leave you out, Ms. Harris.
I think she's on mute.
It's okay. I apologize. We'll blame that on Mr. Barnes.
Yes, I take full blame for that one, but I still be online just in case we
Okay.
need to go back over the proposal.
Okay, I think she's going back to maybe get to the phone possibly, Mr.
Yes, ma'am. I'll still be here regardless.
Okay, I appreciate it.
Yes, ma'am. I just be on mute.
Yes, I forgot they moved.
Judge, whenever you're ready, we can go to position 7, Mr. Harris.
Okay.
Yes, Judge, we're ready for position 7 when you are.
This is case number 22 CR 004020C. Is it Kevon or Kevon Harris? Charged with 1 count of possession of a pistol or revolver by a person under 18 years of age, and a 2nd count possession of marijuana less than an ounce. And this is going to be, is this a plea, I believe? No, it says arraignment, jail jury, arraignment.
Yes, Judge, and I submitted that waiver.
Okay. And you did the waiver of arraignment, okay? All right, Mr. Harris, you've been formally charged in the Solicitor General's office has accused these 2 cases against you. Your attorney has waived the arraignment of the formal reading of the accusations against you. So you have been arraigned. If your address or phone number changes, let your attorney know, as well as the clerk of court, so we can get you those future notice dates for trial. And again, you've been formally charged and arraigned, and your case will be reset for trial with the division judge for further notice, okay? All right, good luck to you.
So he get out there.
Can we do position 5, Glover?
Okay.
What?
Okay, and so 5 non-negotiated plea? Still, yes?
If I haven't heard different, I don't believe. I believe the offer is the same.
Offers the same.
Mr. Dotis and Miss Dillingham?
Yes, Your Honor. We have on the calendar a non-negotiated plea. Our offer remains the same. 12 months to serve, 130 days, credit for time served, 15 days, balance probated. There was actually one change, Your Honor. We had initially requested 12 weeks anger management. Instead, we are requesting family violence intervention program, as well as a no further contact order to the victim, Olivia Glover, and a stay away address from 395 James P. Brawley Drive.
Okay. You may have to read me the,
Your Honor,
You're on mute.
leave you're muted. Here we go.
all right. This is case number 22 CR 008176Y. And that's, last name is Glover, and I'm not sure how to pronounce the first name. Geraldis. Charged with 1 count of simple battery family violence. The offense date March 14th, 2022. How do you pronounce your first name?
Your status.
Your status, okay. And last name is Glover, is that correct?
Yes, ma'am.
All right. Raise your right hand for me. Do you affirm the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am. Yes, Sean.
Okay. And so do you stipulate to the venue identity and factual basis, Mr. Dotis?
We do, Your Honor.
All right. And I'm going to ask you a series of questions, Mr. Glover, in order to accept your negotiated, in order to accept.
I'm sorry, Judge, this is a non-negotiated plea.
Non-negotiated, I'm sorry.
Yes, Your
So-
Honor, if I may, I
Go
do
ahead.
believe the jail time was at issue for the defense.
Okay.
The reason we had requested 130 days was due to the severity of the incident. The defendant grabbed Miss Glover, the victim, by the neck and threw her on the couch and then punched her in the face with a closed fist. And she has stated that she is in fear of danger for her life. And that is the reason that we have requested 130 days.
All right.
Your Honor, can you hear me?
Yes.
Just to add to that, the defendant and the victim, they have a second case that predates this case, 22 CP 205654. And as a part of that bond condition, it was a no contact order in place when this incident occurred. That case is a battery family violence second offense, which is why it's in Superior Court. Just to give the court a little bit more background. And I will also ask that pretrial read any other relevant history that they may have. Is
There is
pretrial
an additional open case, 22 CP 205655. That's also battery family violence.
Okay. Anything else?
No, Judge.
Okay, thank you, Ms. Harrison. And so again, the state wants 12 months probation, 130 days, credit for time served at 15 days. And so how many additional days? And then balance probated.
Yes, Your Honor. That was the 130 days. So with the double rule, it would be 100 days remaining.
Okay. And then, Mr. Dotis, your argument to the additional jail time is no go, and what else?
Yes, Judge. I believe Mr. Glover's last conviction for battery was in 2012. He has no long history of violence in Fulton County. He understands the charges brought against him, and he's open to doing all of the conditions. He doesn't have a problem with that. But we are asking this court to consider a credit time served deal that would allow him to get out and support his 3 kids, all under the age of 10. He understands that he'll be on probation for the full year, and he understands all of the conditions and the stay away. And again, I know we talked about the severity of the alleged incident, but again, the officer did state that there was no visible injury, which is why this is a simple battery. So we would ask for a credit time served to serve 32 days, credit for 16 days. I believe he has 16 days as of today, Your Honor.
Your Honor,
Judge, he also has 2 cycles out of Nevada. 2018, he was convicted on domestic battery, and he had 2 arrests there for the same thing.
Okay.
Judge, please.
And Your Honor, once again, the defense omitted the fact that the defendant has violated his bond conditions for the 2021 battery family violence case, which was against the same victim, Miss Olivia Glover.
And Cynthia Glover is mother or wife?
Olivia Glover is
Olivia.
Wife and mother of his children.
Ex-wife. We got a divorce.
Ex-wife, you're divorced?
Yes, ma'am. We got divorced in May.
Yes.
May right after that. Yes, ma'am.
Yeah,
Okay.
Mr. Glover. Yeah, I spoke with Mr. Glover, and they did get divorced last May, and the contact issue I think has been resolved. I don't think going forward that will be a problem.
Okay. And what about any children? Are there any children?
Yes, Judge. There are 3 kids, ages 9, 8, and 2, and Mr. Glover is the primary provider.
So when you say he's the primary provider, the kids reside with him or just he's providing support?
I believe he's providing financial support. Mr. Glover, if you want to clarify and just leave it at when your kids stay with you.
Lovely Glover is the only child I have by Olivia. My other 2 kids is by Samaria, and yeah, I provide for all 3 of my kids. Matter of fact, Olivia just put me up for child support, and I can't pay.
Mr. Glover, please stop talking.
Well, she just put him for child support. That speaks to the fact that he hasn't been providing, but I digress.
How is that true? How is that true? How is that true? How is that true? That's not true. That's not true.
And roughly 100 days remaining.
It will be 50 with the 2-for-1.
Okay. All right. I will agree to add that if you want to still accept it, Mr. Glove, if you and your attorney, I would ask you to serve those additional 100 days at 2-for-1, roughly 50 days, 49 days. I would include the additional jail time.
So, Mr. Glover, if you can just give me a yes or no on if you want to accept this plea. Can you give me a yes or no? And we can speak further if you want.
Can we have a moment to speak privately, please? Like,
Can we come back to this so I can go speak? I don't want to hold everything up in the breakout room.
I'm not understanding. Like, Matt.
Judge, I'll speak with my client if we can readdress that.
Right. Hold on. He doesn't want you to say that in open.
Why is it so many days I can't provide?
Don't speak.
All right, we can go to another case. Come on, position Position 10, Mr. Lamar.
Okay,
Why? Can we do position 25? Like,
25 instead of 10.
okay,
Is that a yes or a no?
Are we doing 10 or 25?
Which one? We're doing 10 or 25?
Position 10,
Okay.
Arraignment.
And the 10 is an arraignment?
Yes, we're ready on position 10, Your Honor.
Okay. All right, Mr. William Lamar. This is case number 22 CR 00833 2C. You're charged at one count of battery, family violence, and a second count of cruelty to children in the third degree. You and the offense date is December 17th, 2021. Do you waive a formal reading of the accusation?
Yes, Your Honor, and I submitted the waiver last night.
Okay. And I will tell you, Mr. Lamar, with those two counts, you are now formally charged. Your attorney has waived the formal reading of the accusation, but you have been charged again with one count of battery, family violence, a second count of cruelty to children in the third degree. Those cases have been formally accused by the Solicitor General's Office of Fulton County, and these charges each carry a maximum sentence of 1 year in jail or a maximum fine of $1,000 for each. The case will be sent for jury trial, and the trial will be scheduled by the state court judge or the division judge to whom this case is assigned as for the notice for trial. Make sure that we have your updated address and phone number at all times. You don't have the burden to prove the charges at trial. The state, represented by the Solicitor General's Office, will bear that burden and will have to convince the jury beyond a reasonable doubt in order to get a conviction in this case. If they do get a conviction, you could face a sentence again of up to 1 year. Each of those charges and a $1,000 fine. It can run concurrently or consecutively. But based on this information, how do you plead to the two charges?
Not guilty.
All right, I'll accept your not guilty plea, and this case will be reset for trial.
Thank you, Judge.
All right, thank you.
position 25 is next, Judge.
Okay.
Who's 25?
Number 25,
Is
yeah.
that you, McLean?
Yes, I'll be right there. Number 25 is ready for negotiated plea.
Okay. This is 22 CR 000-790Y Khalid Tillery. You're charged with one count of cruelty to children in the third degree and a second count of battery, family violence. The offense date is February the 15th, 2002. State.
Yes, Your Honor. In this case, we have the victim, Miss Tillery. The defendant had punched her in the face with a closed fist. And he had woke her up in the middle of her sleep and attacked her. All of this happened in front of their child, who ended up calling her grandmother, and that is how the police were notified of this case. This defendant does have a high risk of re-offending due to the fact that he has a 15-cycle arrest record, with 3 previous aggravated assault arrests. And so for that reason, the state is requesting 12 months, 100 credit for time served, 53 days, 106 days to serve, balance probated, 8-week anger management, and full-term probation with no further contact to Ms. Tillery and a stay away order from the address 1847 Childress Drive Southwest.
And I would like to clarify, Your Honor, that's actually supposed to be FVIP. That's an oversight on my behalf, but FVIP is statutorily required for any battery family violence charge.
Okay,
So it would be the battery family violence in lieu of the 8-week anger management course.
okay. So I've made note of that. All right, are we ready to take the plea, Mr. Tillery?
Yes, ma'am.
Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, and do you stipulate, I'm sorry, you put your hand down. And this is Mr. McLean, right?
Yes, Your Honor.
Do you stipulate to the venue, factual basis, and identity?
We do so stipulate, yes.
Okay, all right. Mr. Tillery, I'm gonna ask you a series of questions regarding your guilty plea. First one being, are you under the influence of any medication, drugs, or alcohol at this time?
Ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
And do you understand that by waiving and giving up your rights, you are waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And you're waiving and giving up the right to a trial by judge or jury, whichever you prefer?
Yes.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
All right, and do you understand that if you're currently on probation, your probation may be revoked because of this guilty plea you're saying?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you? And so again, as to the charge of cruelty and the third and battery, how do you plead?
Guilty.
All right. And you've heard the conditions. Do you have any questions about your conditions?
No, ma'am.
Okay, so you got a lot to do, so get started on it when you get out.
Okay.
All right, anything else?
Yes, Your Honor, I just need to make sure that he understands something. Mr. Tillery, if there are any other matters pending, are you satisfied that this is the correct thing to do for you? Is this your decision for this case?
Yes, sir.
You heard the state orally modify what you and I signed last night or yesterday afternoon. You heard them change that from 8 weeks of anger management to a recommendation of FVIP, which is a 24-week course that you can't skip any class or you have to start all over. It is expensive at $35 per class, and it's a big deal. Do you understand about FVIP?
Yes, sir.
You understand why they modified it? They stated the law requires that.
Yes, sir.
So fully understanding that, I think I will stand by my statement, Your Honor, my signature that he understands what he's doing today. I've already prepared this for email with the existing, but we have orally modified the recommendation to stay, and he says he's okay with that.
Okay. Right, anything else, counsel, that we need to take up?
That's it, Your Honor.
Nothing further from the state, Your Honor.
All right.
Your Honor, I see South Annex is back. Since we have probation and private counsel on the line, do you mind going back to Ms. Worthen's case?
No, that'll be fine. Can we go back?
We're ready to proceed, Your Honor. Thank you.
Okay.
And I don't know if you want to do the probation matters first, then the plea, or what's the court's pleasure?
Whatever's convenient. If you want to do the probation matters, we can do that since Mr. Barnes is only here for that.
Okay.
Mr. Barnes?
Yes, ma'am. Good afternoon. Good morning. I'm sorry, still good morning.
It's still morning, a little
Yeah,
bit
still
left.
morning.
All
All right,
right.
yeah. We're gonna deal with the case in 22 CR 002743. This case was before Judge Edie on May 17, 2022. At that time, Ms. Worthen was sentenced to complete a domestic violence counseling program, stay away from the 3961 Blanton Avenue Southwest, no contact with Tamika Jackson, and to complete the domestic violence counseling program. On that particular case, Your Honor, there's 131 days remaining on that case. And according to our records, we do not show that Ms. Worthen has completed any of the domestic violence counseling program. And she has never reported to probation. Second case, 21 CR 001598. This case was also before Judge Edie on June 23rd, 2022. Was sentenced to do the domestic violence counseling and to stay away from Sharon Worthen, complete a mental health evaluation and complete domestic violence counseling, and to stay away from 3375 to Wonder Drive, South Fulton, Georgia. On that particular case, probation does not have any proof of completing any of the conditions that was initially court ordered, and Ms. Worthen has never reported to probation. On this particular case, 131 days left on this particular case. The third case, case number 21 CR 004971Y. Ms. Worthen was also before Judge Edie, was sentenced to do 12 months of probation to domestic violence counseling and no contact with Danielle Worthen's. 131 days remaining on this particular case. Probation have no proof of completing the domestic violence counseling and has never reported to probation. Case, again, time left on this case is 131 days. The last and final case, case number 22 CR 004328Y. This case was also before Judge Edie, was also sentenced to do 12 months of probation to complete anger management counseling, no weapons or drugs while on probation, no contact with Candace and Brady, and to stay away from Grady Hospital unless receiving treatment. Ms. Worthen's never reported to probation. On this case, it's 193 days remaining on this case. At this time, it was my understanding that the recommendation for the probation department will be to revoke the balance on all four of these particular cases. Cases ending in 743, 131 days. Case ending in 598, 131 days. Case ending in 971, 131 days. Case ending in 328, 193 days.
Okay. All right, State. Do you? That's being presented.
Do you want to hear from Attorney Lynch first or me? Because I think.
Your Honor.
Oh, that's right. I'm sorry. Yes, Mr. Lynch.
Your Honor, that is correct. We do stipulate to the violations of probation as alleged. Our understanding is that the recommendation for the revocation of the balance, they're to run concurrent and to be concurrent with the pleas that we're entering as part of this as well.
Okay, good. All right, well, I will accept those recommendations from probation. And she will just remain to complete, correct?
My understanding is that after the service of the sentence, the cases will be closed.
Then they will be closed and she will no longer, right, be on
Right.
probation, okay? Just make sure everyone understands that. And then there's a stay away in the 3961 Blanton Avenue Southwest.
Well, I think because probation will be closed out, there won't be any conditions.
Oh, by the time she does yours, okay.
Yeah, so she's going to serve the balance of her probation, close that out. They'll be reported as probation violations. And then on ours, it's a full 12 months to serve, 365 days concurrently on all counts. So there won't be any conditions because there's no balance to suspend or probate at that point.
Gotcha, okay, all right. I am clear. That's fine, I will approve that.
She shall be given credit for 132 days that she has spent in custody at the Fulton County Jail.
Yes, I'll give her credit for those 132 days. And then now I will go ahead and accept her plea to that for the state. For in both cases, right? Running concurrent.
Yes, Your Honor. I'm not sure if you want to go through those independently and put them on the record, but of course, my understanding is that she would be pleading guilty to 22 CR 008-008Y and 22 CR 007 or 007-848Y, and that the recommended sentence would be 1 year to serve with credit for the 132 days that she served on 22 CR 008-008Y, also to run concurrently with all four of the probation violations that were just put on the record. But I guess we still need to go through the plea, so I'm getting
Right,
that.
and now, right, I'll do them all as a joint plea for all four charges. I could just do that once, do that together. Ms. Worthen, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, and again, Mr. Lynch, you stipulate to the venue, identity, and factual basis?
Yes, Your Honor.
All right, Ms. Worthings, I'm going to accept your plea regarding two cases, one ending 22 CR ending in 848Y and 22 CR ending in 008Y. That is one count of simple battery, one count of disorderly conduct, one count of battery, and a fourth count of criminal trespass. Is that your understanding that you're pleading guilty to those four charges?
Yes, ma'am.
All right, let me ask you a series of questions. Are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up the right to try by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared to agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea fully and voluntarily with the full understanding of the four charges against you?
Yes, ma'am.
And as to the charges of simple battery, disorderly conduct, battery, and criminal trespass, how do you plead?
Guilty.
All right, that is fine. I will accept that guilty plea. And also the recommendations and what will happen with probation after giving you credit for the time served, the 132 days, and you've resolved your matters satisfactorily to me today. I want to wish you good luck going forward, okay?
Okay, may I ask you a question if you don't mind?
Yes.
I just want to make sure I know how many days I have left to serve. Was it going to be like 2 for 1 that he was telling me? I just wanna make
Yeah,
sure.
they do give you the 2 for 1. And so someone do the math for me, please.
My understanding, well, I've done
48, 48 days would make 180.
Mhm.
Is that correct, Mr. Lynch? I think 48 plus 132 equals 180.
Right, so she's done 132 days, so that would get her to what, 260. So she would have a remaining like approximately 2 months to serve.
Yeah, 48 days. So
48. Mhm.
a little over 6 weeks.
I believe it should be maybe about 116, 117 days remaining with the 2-for-1 credit.
No, she served 132 days so far.
Right. If
Yeah,
you
we're giving
She's
her
required
credit
to
for
serve
that.
180. Well, give or take, because it's 365 days in a year. A little less than 2 months, we'll say that.
That was my understanding.
It should be a little less than 2 months.
I'm gonna rely on you all for the math.
That's giving her the 2-for-1 for the time she's already served. I'm not sure if that's the.
Right,
Yeah,
and
you're right.
that's her question. And help us out, Mr. Barnes.
I believe it's like 50. Yeah, I believe it's like less than 2 months. That's correct, Mr. Walker.
Okay.
I just put out my calculator.
Look, I have my
51 days is my official answer, about 51 days.
Yeah, exactly.
All right.
That's the same thing I came up with.
Okay, so you heard that, Ms. Worthen?
Yes, ma'am. Thank you.
All right, thank you. Good luck to you.
Thank you.
All right.
Your Honor, I'll get those signed stipulations as well as the plea form signed with express condition
Yes.
over. Should be within an hour or so. I have a little issue with my printer, but I'll try to get that done within the next hour.
Okay, great.
Thank you.
Can we go back to position number 5, Glover? He said
Okay. Position 5. Oh, yes, he was going to speak with his attorney.
But he said he's gonna go ahead and take the plea.
Okay.
Your Honor, if I may,
Yes, Mr. Barnes.
I was that concludes, I believe that concludes our business. May I please be excused?
Yes, you may. Have a good holiday, Mr. Barnes.
Thank you, same to you. Thank
Hold
you.
on one second, Mr. Barnes. Mr.
Before
George.
Mr. Barnes leave, so what is the sentencing condition that's going to be written on the probation order?
It's going to
Or
be
Ms. Worthen?
revoke the balance credit for time served.
So how much of the balance is going to be revoked?
You want me to go over the cases with you?
Oh, I see the cases. I'm just trying to figure out how much of the balance is going to be revoked, because so let's just say, for instance, for case 2743Y, 22 CR 002743Y, with the incident date of 5/3/22, Ms. Worthen spent 52 days in jail and was released on 6/24/22. So
Right.
if the remaining balance is, so they're going to subtract those 52 days that she served on that case from the remaining balance.
Yeah,
So she may have to do more time.
Yeah, we've already
Yes,
given her credit for that time frame.
Right, but what's going to be the remaining balance that she has to do?
131 days as of today. So basically with this case and the next 2 cases, which is the one ending in 598 and the one ending in 971, those cases are going to be commuted to time served, because there's only 131 days left on those particular cases, and she's already served 132 days.
132.
So what I'm saying is the jail is only going to give her credit for the case with the incident date 5/3/22 of 52 days. The case with the incident date of 3/31/22, 52 days, and 4/2/21, 52 days, minus whatever time y'all take off her probation. She's only going to get 132 days credit on the case with incident date 8/13/22 and 11/16/22. They only give her credit for time she served in jail on each incident date case. That's what I'm trying to understood when it comes to time served.
Yeah, her time is going to be served anyway because she's already with the 1 year that was proposed, that would be enough to serve all of her time frame. But basically, what's going to read on the petition is going to revoke the balance credit for time served on all 4 petitions.
So one case she has a time served date of July. In another case, she has a time served of June, and another case she has a time served of May. So she would have 5 months, 6 months, and 7 months on 3 different cases.
Right, but again, the course is giving her 1 year of serving with the credit for time served. Right.
That's what I'm trying to get y'all to understand. That when the jail starts calculating credit for time served, they only calculate time that you've already spent on one particular case. So they're not giving her 132 days on the probation cases. They're only going to give her the credit for the 52 days she already served.
You talking about in the beginning or right? Because in the beginning, she served that time.
For instance, she got sentenced in June. She has 7 months remaining on that sentence. I'm sorry, the case that she got sentenced in July. She has 7 months remaining on that sentence. If they gave her 2 for 1, I mean, I don't know what 7 times in the days. But if they gave her 2 for 1, then she's only getting 104 days credit on the case that she took a plea in July.
Well, the last case, the case that was sentenced on July 19th, it was the remaining balance was 193 days on left that case as of today. So if with the 2 for 1 credit, she'll be given 96 days or 96.5 days. But she's already served 132 days already. So technically that will make her case time served.
So she's not serving any time on any one of the probation cases?
No, she's already served that time already by doing the 132 days that she's already been in jail since she's been in jail since August the 13th, 2022. So they're going to give her credit towards that 193 days from August the 13th.
So that's what I'm trying to explain to you.
So can I think I understand what you're saying, Mr. Jordan. So, and I tried to address this with probation previously, but I believe because a warrant was not taken out, a booking number was not created for these probation violations. Yes. So technically she was not booked in on the violation of probation because no warrant was served or executed. So I think what Mr. Jordan is saying, because there was no warrant, there was no booking number, she's not booked in, the clock was not ticking on the VOP. Is that what you're saying, Mr. Jordan?
Yes.
So a way to get around that, if we could just change the petition to time served and we just report it as a violation, I'm fine with that because she still will be serving a year to serve on her 2 open cases. So for paperwork purposes, if we just want to put probation revoked, commuted to time served, would that be sufficient, Mr. Jordan? Or do you need an exact day, a number of days?
They don't have to try to calculate how many more days she's got to serve between the 5, 6, and 7 months. Because she would end up getting additional days past.
So what do you recommend as far as how it needs to read?
Oh no, that's fine. Like you were saying, time served.
Okay. So just balance revoked, commuted to time served. And then the paperwork on the pleas will state 12 months to serve 365 days, credit for time served 132 days, because she has served 132 days on those cases.
Yes.
Yeah, and Mr. Walker too, because there's no probation warrant that was issued on these particular cases, time was still currently running while she was in jail. Correct. So, yeah, so there was no tolling order stopping the time. So actually, time is still running.
Right time, exactly. So she wouldn't technically be given jail credit for those days because she technically is not being held on a violation of probation.
Gotcha. I see what you're saying. I see what you're saying. I got it. Yeah. But either way it goes, that's the word is going to be revoked the balance credit for time served. Yeah, credit for time served.
That should work.
Okay.
Thank you.
No problem.
Thank you for that.
Do y'all need me for anything else?
Can we go back to this position 5, Glover now?
Go ahead.
May I interject an announcement, Your Honor? Oh, I'm muted.
No, you're not.
Oh,
They could hear you. She's muted.
I see.
I'm sorry, I was muted. I apologize.
Very good. 15 and 16, if we have time. 15 and 16 is a negotiated plea.
All right, we're doing Glover first and 5 to finish him. Now that Glover's ready for the plea, I thought, no.
Mr. Glover, do you want to go forward with the plea? All right.
It's 50 days or something like that, right?
Right.
39, 49, something like that.
Yes.
Right.
I do want to make sure we're accurate on the credit. I think today he has 16 days of credit, not 15.
It's 16 days of credit.
He's talking 39.
Yes, it's 16 days.
Okay. And so do the math for me, someone. It's 130 days. Credit for time served at 16 days.
Yeah, you should have 49 more days if my math is correct.
All right. Is everyone clear and together on that, Ms. Dillingham?
Yes, Your Honor, that's what I have as well.
Okay. All right. Are you clear on that, Mr. Glover?
Can I get a date or something around when I get out? Like,
We don't give you a date because we can't promise the date. We'll tell you the days. Because, you know,
can you tell me the month?
For the 49 days left that you have.
Yes, ma'am.
So that's a month and 19 days. So 1 month and then 19 days in the second month. Is everybody, am I saying that correct?
Yes, Your Honor.
Yes,
So one month and 19 days. Okay. All right. And so I refresh my memory, you all. Did I go through the plea soliloquy with you?
I don't believe so, Judge.
Okay. All right, Mr. Glover, did I swear you in, I think?
Yes, ma'am. Right.
I swore you in. And so again, Mr. Glover, I'm going to take a guilty plea to 22 CR 008176 to 1 count of simple battery family violence. And we have heard the terms of the plea state. Could you just repeat that real quick for me? Did you hear me, Ms. Dillingham? Can you just?
I did not, Your Honor. Could you repeat that?
Can you repeat the terms of the plea real quick for me?
Yes, Your Honor. So it's going to be 12 months to serve 130 days, credit for time served, 16 days, balance probated, family intervention program, no further contact with Olivia Glover, and stay away from 395 James P. Brawley Drive.
All right.
Judge, we would request for the probation fees to be waived, since it's balance probated. And if the state is open to it, we would ask for Mr. Glover's probation to switch into non-reporting status once he's completed the conditions.
All right. Any objection from the state?
No objection to the non-reporting, Your Honor.
All right, once you complete the terms, and that FVIP, I believe, is 24 weeks.
That's correct.
And so you've got to take them all. If you miss, you have to start over. And so because of the cost and that, I'll waive your probation fees, Mr. Glover, so that you can complete those courses. And then you also have the 12-week anger management. So I'll help you out by waiving your probation fees. And once you complete those, you'll still be on probation. You'll just be non-reporting.
Judge, my understanding was that I thought the FVIP replaced the anger management.
The FVIP was instead the 12 weeks.
I'm sorry. Thank you.
No
So
problem.
no 12 weeks, just FVIP. Okay.
Thank you, Your
Yes,
Honor.
Your Honor.
Yeah, thank you. All right, so only FVIP, okay? The 24-week program. All right. So if all minds are clear, let me ask you these questions. Real quick, Mr. Glover, are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am. I mean, no, Your Honor.
Are you satisfied with the services and representation of your attorney?
I would like less days, but yes, ma'am. I guess, yeah. I'm honest.
All
I'm
right.
sorry.
Do not tease him today, so you are satisfied, right? Okay, thank you. Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And that you prepare and agree to waive these rights today? Has anyone told you that you'll receive a lesser sentence for pleading guilty?
We negotiated a less sentence about 10 days. It was supposed to be 39 days instead of 49. But I guess, yeah.
Sometimes they're kind of rounding out the math, so we're going to charge that to the math calculations.
That's fine.
It looks like it's 49, okay?
That's fine.
All right, has anyone promised you anything to plead guilty?
Oh, no. No, ma'am.
Okay, do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
And so as to the charge of simple battery family violence, how do you plead?
Guilty.
All right, I will accept your guilty plea. And if that all minds are clear, that will conclude this case.
Yes, Judge. I would just ask Mr. Glover, do I have your express consent to sign on your behalf the document that the judge just went over with you? We went over it in person together. Can I get a yes or no?
You have to answer. Yes or no?
Thank you.
I was looking for his name. I forgot his name, but yeah.
Okay.
Oh.
Okay, Mr. Dotis, but nice to see you again, Mr. Glover.
Yes, Mr. Dotis. Yes.
Dotis. I appreciate it, Mr. Dotis. Y'all have a Merry Christmas.
All right, you too. Thank you.
Next judge, position 9, Mr. Jones.
Okay. This is 22 CR 008179C. Let's see, I have that as a non-negotiated plea.
At this time, Judge, waiting to hear if the state wants to resolve anything with the jail time at issue.
Okay, jail time. This is one count of SB state.
Your Honor, we have 12 months to serve, 60 days, credit for time served, 16 days, balance probated. We're standing firm on the jail time.
And then I see a SDET.
Yes, Your Honor.
Stay away and no further contact with the victim.
Yes, Your Honor. The victim's name is Asia Alexander.
All right.
And we would go forward with a non-negotiated plea, Your Honor.
All right. Let me have history, either pretrial or Ms. Dillingham?
I do have the state has found that this defendant had a simple assault arrest in 2019, a criminal trespass arrest in 2019, a willful obstruction conviction in 2020, and a theft by shoplifting conviction in 2007.
All right. How many arrest cycles?
I would defer to pretrial services for that.
Okay. Ms. Harrison?
He has, one moment.
Okay.
He has 17 cycles. He also have an open felony case, 21 CP 202092, entering auto.
All right. All right, based on his history, I would have him to serve the remaining, how many days?
It would be 14 days, Judge, but if I may address some issues with it.
Okay.
The case. Judge, my client wants to resolve this case and he's willing to do all of the conditions mentioned. He's willing to do the full year of probation, the sexual deviancy program. He wants to resolve this case. Both my client and the complaining witness were arrested that night. The complaining witness was arrested for public drunkenness, and alcohol played a big role in what happened that night. Mr. Jones is willing to accept the responsibility for his part, but alcohol did play a part in this, and both my clients and the complaining witness were arrested. Mr. Jones is the primary provider for 2 of his children. He has a total of 5 children. He understands he'll need to complete all the conditions listed, and we heard from pretrial and Ms. Dillingham his history. He doesn't have any other charges of this nature. He does not know this victim, so stay away, no further contact won't be an issue. It's made clear many times throughout the report that they don't know each other. So I don't think any contact will be an issue in the future of this nature. And for these reasons, he served 16 days as of today. So we're asking for him to serve 32 days with credit for those 16 days and get started on his probation and get back to his family.
Does he have employment?
Yes, Judge. He has his own business, Parking Lot Music Inc., which is his primary source of income. He also has his commercials driver's license, and he's looking to utilize that.
How old is Mr. Jones?
How old are you, Mr. Jones? 35. Mr. Jones is 35 years old.
What say you state again?
Your Honor, if I may just have one moment.
Okay. All right. We'll hold for a second.
Your Honor, the state is ready. Thank you for that time. So we are agreeable to the 32 days credit for time served, 16 days.
Okay.
As long as the defendant meets all of the conditions that include the SDET, the stay away order, and the no further contact.
Okay, got you. All right, and do we have the stay away address? I don't believe I heard it.
I don't know if they're, I'll let the state go. I don't think we have them now.
We don't? Okay, let's see.
Yes, Your Honor, I beg the court's indulgence. We do not have an address for the stay away order. So just the no further contact.
Okay. Well, I can, he has no further contact with the victim. So that essentially means stay away from her wherever she may be. Okay.
Right. This incident took place in a construction site. So,
okay. So it was not at a residential location, you think? Okay.
Yes, Your Honor.
Gotcha. All right. Let me raise your right hand for me, Mr. Jones. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
And what I'll do, Mr. Jones, I will add this to it. I will just waive half of your probation, please, okay?
Yes, ma'am. Thank you.
All right, trying to give you a start there. All right, you can put your hand down. Are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you are giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared to agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
And so as to the charge at SB, how do you plead?
Yes.
All right, and so we will accept that 12 months, you serve 60 days, credit for time served for 16 days. Balance will be probated until you complete the SDET. And once you do that, you will go non-reporting.
They changed it to 32 days.
I'm sorry, 32.
Just changed it. Okay.
I'm sorry, and I said it and thought it at the same time, 32 days. I will waive half of your probation fees. And what else do I leave out? Oh, I'm sorry, no further contact with the victim, Aisha Alexander, which means no contact with third parties, no email, no social media. Don't have anyone else to contact her for you, because all those things would be violations. So I'm expecting that you will do well with your probation and get back on track, okay?
Yes, ma'am.
All right, good luck to you. Thank you.
And I would just ask, Mr. Jones, do I have your express consent to sign this document on your behalf that the judge went over? Okay. Thank you.
All right, thank you.
Next, we have position 21. Mr. Solomon.
Which one?
21. To Mr. Solomon.
ACDC, hold on for me for one moment, please. It's our Johnson. Thank you.
Okay. So we're 21 or?
Position 22, Mr. Solomon.
22, okay.
This is a negotiator.
All right, position 22, this is Santori Solomon, 22 CR 008201A. You're charged with 1 count of simple battery family violence. And this is a negotiated plea.
Correct,
This
Your Honor.
is January the 10th, 2022. All right, state.
Yes, Your Honor. The state is recommending 12 months, 32 days to serve, credit for time served, 16 days, balance probated, alcohol, drug evaluation and treatment, 8 weeks anger management, a stay away from 5285 Britain Trail, as well as no further contact with Miss Kelly Longino, and a third-party visitation with any shared children.
All right. Is that your understanding, Mr. McLean?
Yes, Your Honor. In addition, he would like the court to consider any financial break that he could get because he's concerned about his income when he comes out of jail.
Okay. How old is Mr. Solomon?
I have that on the
43.
contract sheet. 43 years old.
43. Thank you. I will waive half of the fees.
Thank you.
Okay. All right, Mr. Solomon, you're ready to take a plea?
Yes, ma'am.
Raise your right hand for me.
Can I ask you a question, ma'am?
It depends. It may be a question maybe for your attorney. Is it about?
I'm on felony probation as well. Is there anything?
We don't deal with that in this.
Okay, okay. All right.
Okay. Your attorney will explain that to you.
There's part of the plea statement that addresses possible consequences on other probations. Other than that, that's it.
All right.
Okay. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you put your hand down. Are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Correct.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
Do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
And do you understand that you're waiving and giving up the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you're prepared?
Your Honor, excuse me.
Uh-huh.
If we could, I'm sorry for the late objection, but if we could just object to the suspension of the fees or half of the fees. I'm looking at his record. He has quite an extensive record. He's got a conviction for firearm possession, as well as two open warrant for 2 charges out of Ohio, one for crimes against person and menace by stalking. We have reason to believe that evidence that he violated the bond condition and has been in contact with the victim, even as going as far as asking her not to participate and not to move forward with the prosecution. So she's afraid of him, and so we would just object to any mercy you have as far as the bond fees go.
Money punishments have to do with the word fine. A fine is a money punishment for part of a sentence. The fees has to do with his financial condition. He says that he will have financial problems, and that is an appropriate factor to consider for whether he should pay or be waived on some fees.
Your Honor, the defendant is of working age. We see no reason that he's not able to obtain employment and pay probation fees. We understand everybody's going to have some type of difficulty paying the fees, but this is why the probation fees are in place, to ensure that he's following the regulations of the fees, or following the regulations. We understand, but he's of working age and he can find employment upon his release.
Well, considering the history that you gave me, I'm not so sure that he will be able to find employment. And I do understand trying to give him a start to get his life back together, hopefully. So I'm going to overrule the objection and still waive half of his probation fees.
Thank you.
All right. Thank you. Let me go ahead. I think I asked the last question I asked, has anyone promised you anything to plead guilty?
No, ma'am.
All right. Has anyone told you to receive a lesser sentence for pleading guilty?
No, ma'am.
And if you are currently on probation, this guilty plea today may be revoked or affect your probation. Are you clear on that?
Yes, ma'am.
Okay. And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, Your Honor.
All right, so again, as to the charge of simple battery family violence, how do you plead?
Guilty.
All right, guilty. All right, so you understand the conditions. You have to, it's 12 months to serve 32 days, credit for time served is 16 days, balance probated, an ADET evaluation, 8 weeks anger management, stay away from 5285 Brittany Trail South in South Fulton. No further contact with Kelly Longino. And if you are granted any visitation with shared children, it must be conducted by a third party so that you do not violate the terms of your probation by having any contact with Ms. Longino. All right, do you understand that?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
All right, thank you.
Position 15 and 16 is next, please. I know. Get right in the bush, put your man up.
All right, who do we have next, deputy?
15 and 16.
15 and 16, okay. This is Moody.
Yes, Your Honor.
I don't know how to pronounce the first name. Is it Darius?
Yes, ma'am.
Okay. So we have 21 CR 001870E. One count of PI, public indecency, offense date 3/30/2021, and then 22 CR 008182E. The second count with the offense date of December the 7th, 2022. And I believe these are, it said hold for announcement. So are they negotiated or non-negotiated?
Negotiated plea, Your Honor. We noticed there was probably a typo in that a certain number of days.
Oh, okay. Okay.
One of the recommendations, but put in context with the other case, we're thinking that it's probably about the same recommendation.
Okay. Got it. All right, state.
Yes, Your Honor, we have 12 months to serve, 90 days, credit for time served, 16 days. This is, I beg the court's indulgence, Your Honor, one moment.
Okay.
Thank you.
Oh, wow, I'm glad you're doing this.
Oh.
My sincerest apologies, Your Honor. So the recommendation is 90 days credit for time served on the first conviction, on the first charge, 16 days, and then credit for time served on the second charge, 14 days. Balance probated and a stay away order from the MARTA train station.
Okay. And so no SDET?
As well as an SDET, Your Honor.
Okay. And then on the, I see on the 870E case, there's no further contact with the victim, but I don't see it on the second one, the 182E.
So for the no further contact from the victim, that will be victim Monique Edwards, who is the complainant in this case. So we are asking for no further contact from her on that case.
Okay. All right. Got that. And then on the second one, correct?
Yes, Your Honor.
All right. So is that your understanding, Mr. McLean?
Yes, Your Honor. The victims are strangers and he would have no idea, probably wouldn't recognize them again to run away from them, but he agrees and understands the concept. The 855 East Pace's address is something he can agree to. It's probably not relevant. Both cases have to do with the MARTA train car, being on a MARTA train car. He will be staying away from MARTA anyway.
Right. Okay. All right, if we're ready to take the plea, I will do that. Mr. Moody, can you raise your right hand for me? You affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, so let me ask you a series of questions. Oh, Mr. McLean, you stipulate you give your identity and factual basis?
We do.
All right. Are you under the influence of any medication, drugs, or alcohol at this time, Mr. Moody?
No, ma'am.
Do you understand that by pleading, I'm sorry, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
Yes, ma'am.
Do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
And as to the 2 counts of PI, how do you plead?
I'm pleading guilty, ma'am.
All right, that is fine. You've heard the conditions of the state to that plea. Hold on a second. And so again, the first case, 12 months to serve 90 days, credit for 16, balance probated, to stay away from that 855 East Paces Ferry. That's the MARTA station, I believe. SDET, and no further contact with the victim, Monique Edwards. Is that correct, counsel?
Yes.
And then on the second one, serve 90 days, credit for time served, 14 days. And the same of their stay away conditions. And then the SDET as well. Anything else left out?
No, Your Honor, the SDT, which is an expensive evaluation, will be done as soon as he can do it. He's going to do his best to try to do it on a timely basis, and will make all his best efforts. We understand, of course, there's one SDET because although it's in both, there's just one evaluation to be done.
Right. Right, just one evaluation. All right, that will conclude this case, these cases rather.
That's your probation. Probation office, 132 Mitchell Street. If you haven't heard from them in a couple of weeks, you go there.
Can we do position number 20, Reeves?
Okay. All right, this is case number 22 CR 008197, Jeremiah Reeves. You're charged with 5 counts, 1 count possession of marijuana less than an ounce, willful obstruction of a law enforcement officer, 3 counts, and certain acts on bus rail station prohibited. The offense date is 12/8/2022. State.
Yes, the state is recommending for counts 1 through 5. It'll be 12 months with 26 days to serve. Credit for time served, 13 days. Balance suspended. We just ask that the defendant comply with any MARTA suspensions in place.
Okay. All right, is that your understanding, Mr. McLean?
Yes, Your Honor. Great.
Okay. All right. All right, Mr. Reeves, I understand that you would like to plead guilty. Is that correct?
Yes, ma'am.
All right, I'm going to swear you in and then ask you a series of questions. Raise your right hand for me. Do you affirm that the testimony that you're about to give is nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. Mr. McLean, you stipulate to venue, identity, and factual basis?
We do so stipulate.
All right. First question I have for you is, are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
And you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And you're giving up and waiving the right to trial by judge or jury, whichever you prefer.
Yes, ma'am.
Are you prepared to agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Have they told you, promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, I will accept your guilty plea to these 5 charges. And you understand the conditions, correct?
Yes, ma'am.
All right. Any other questions about the conditions? Just stay away from Marta.
No, ma'am.
Okay. All right. Anything else, counsel?
Nothing, Your Honor.
Okay. All right, that will conclude this case.
Judge, I got a quick announcement for position 13. It's going to be a medical reset.
Okay. Hold on a second. 13, McFadden.
What's going to be the reset?
Do you have a reset date or you just want me to do that? Well, we're not having court tomorrow, is that correct?
No,
That's correct, Judge.
This is SAP, so,
Oh, I'm sorry, this is SAP, I'm forgetting, you know what I'm thinking about, Steve, I'm sorry. So what's the next?
reset it a week out.
We set it a week out, deputy?
That's fine, Judge.
Okay. That'll be 12/29. Anything else?
Your Honor, did we address position 8? That would also be a reset, but I don't have a date for that.
You don't have to.
Let's see. Position 8, I did not, deputies, did you say anything about 8? Oh, I see. Social worker visit needed.
How long they need to?
Yeah, do you need a week or 2 weeks or what?
Just a week. It's a credit time served offer, but the client has housing issues and he wasn't at this time ready to accept.
29.
Okay, that'll be 12/29.
Thank you, Judge.
Mhm.
And we're completed here in courtroom 2, Judge.
All right, thank you. Have a good holiday. If I don't see you again.
Thank you. You do the same.
Thank you.
Position 21.
Okay. All right, 21 is Bridgelyn Salter.
Yes, ma'am, Bridget.
Bridgelyn, sorry if you mispronounced your name. Case number 22CR008200Y. The charge of 1 count of battery and a 2nd count of cruelty to children in the 3rd degree, both with the offense date of 12/7/2022. What do we have, state? Let's see. Mine says negotiated plea.
It is, Your Honor.
All right. That offer, Mr. Abdullah. Uh-oh, you muted. Go ahead.
Sorry, the state is recommending 12 months, 30 days to serve, credit for time served, 15 days, balance probated with the 8-week anger management course. Probation can be suspended upon completion of the anger management and proof of employment. There's also a stay away from 24710 National Highway and a no further contact with Kiana Martin or minor child.
I'm sorry, I did not get it.
All right. Mr. McLean.
Those are the terms, Your Honor.
All right. So we're ready to take the plea?
Yes.
All right. Ms. Salter, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. I'm gonna ask you a series of questions. And again, Mr. McLean, you stipulate to the venue identity and factual basis?
We do so stipulate, yes.
All right, and Ms. Salter, the first question is, are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
All right, are you satisfied with the services and representation of the attorney?
Yes, ma'am, I am.
All right, and do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes,
That you're giving up and waiving the right to remain silent and not testify against yourself?
yes, ma'am.
And that you are giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
Are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, that probation may be revoked because of your guilty plea here today?
Ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
Okay. And again, to the battery and cruelty to children, the third, how do you plead?
Guilty.
Okay, all right. And do you understand the terms of the conditions? It says that the probation can be suspended upon completion and proof of employment, and to stay away from 2471 Old National Highway and no further contact with Keona Martin and the minor child. You aware of those conditions as well?
Yes, ma'am.
All right. If there's nothing else, this will conclude the plea, and I would say good luck to you.
Thank you. Next, you
Thank
have
you.
position 23.
All right.
Thank you.
This is 22 CR 008215F. And it's Robin Asia, I believe, Stinson. Okay, you're charged with one count of criminal trespass and damage to property and a second count of criminal trespass, both with the offense date of December 9th, 2022. State.
Your Honor, this is a negotiated plea. The state is recommending 12 months, 28 days to serve, credit for time served 14 days, balance probated. Yes, balance probated upon proof of employment, or we just asking for proof of employment and the probation can be probated or changed to non-report. And there's a stay away from 4335 Food and Industrial Boulevard, no further contact with Kadir Saeed, which is the store clerk at that location.
All right. And is there no further contact with the victim?
Yes, that would be that would be the clerk or employee of the store.
Of the store, okay.
Right.
So you still want to recommend that, Mr. Abdullah?
Yes. But if she stays away from that location, she has no reason to see Mr. Kadir Saeed.
Correct. All right. Mr. McLean, anything in addition?
Nothing an issue, Your Honor. Those are the terms, and we stipulate to the 3 elements that are necessary.
Okay. All right. So it's Stinson, I'm getting ready to take your plea. Can you raise your right hand for me so I can swear you in? Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury? Let's see, I can't hear you. Say something again.
Yes, ma'am.
Oh, okay, now I can hear you.
I don't.
Okay. I understand.
I don't care.
I'm sorry.
Oh, this may not be going well, Your Honor. Miss Stinson, are you prepared to listen to the court, or do you feel ready to take the plea? Do you feel that you understand what we're doing?
What's the plea?
As we discussed last night and as we.
Okay, I can say that, but I'm not taking this. I'm not taking that. I feel like I should, you say I was gonna get plea, you say you were gonna let me plead guilty and I was gonna get probation and I was gonna go.
With the terms of stay away from the
So wait,
store.
4335, that was Industrial Boulevard.
Okay. So do you understand the terms of stay away from the store and stay away from the person if you should ever see him again?
Yes.
All right, on probation, you're gonna prove that you have a job. Okay, you understand the term? You understand the terms?
Yes.
Okay.
All right, are you ready to take the plea, Ms. Stinson?
Yes, ma'am.
Okay. Are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
Do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
Are you prepared and agree to waive these rights today?
You talking about get guilty charge? The guilty plea? Yes, ma'am. Yes, ma'am.
Okay, and has anyone told you that you will receive
So I
a
just checked on the case. He's still,
What's that, Judge Regina Missy?
I'm sorry.
Yes, I'm sorry, that was someone else. All right, you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you you receive a lesser sentence for pleading guilty?
I don't understand what you're saying, man. I'm just trying to take what my attorney said.
I understand, but they didn't promise you anything to plead guilty, did they?
No, ma'am.
Okay. And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
I'm saying though, they told me that if I take my guilty plea, I can go home.
That is true, but I just wanted to make sure that you understand if you were on probation. If you're not, then it doesn't apply. But I have to go through certain things that I need to tell you to make sure you understand and that this is a voluntary plea, okay? So if you're on probation, it could affect your probation if you were. You understand that?
Right.
Okay, and so do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
Okay, so as to the criminal trespass, damage to property, and the second count of criminal trespass, how do you plead?
Yes, absolutely.
I plead guilty, ma'am.
Great, all right. And so again, you understand your conditions.
Stay away from store and no contact with the victim, the man who the store man.
Yeah, that's definitely do that. And they say that you can go off of reporting if you have proof of employment.
Okay.
Okay, I can get a job any day, ma'am.
Very good.
Well, good, then you'll be halfway there. And to stay away from 4335 Fulton Industrial Boulevard, right?
Yes, ma'am.
Okay, so good. I wish you good luck in this, okay?
Okay. So I'm going home today?
As soon as they process you out.
If nothing else is holding you, you will. Good luck. It was good to meet you, Ms. Stinson.
Okay.
Yeah, position number 26.
Are you ready? Okay. C-O-L-L-I-E-R. Road, Northwest. Apartment 1422. Atlanta, Georgia. 30318.
26 is white.
Yes.
Okay. This is 22 CR 008202C. The charge of one count is simple battery. And the offense date is 11/15/2022. Is that correct?
Yes.
Okay. And so state, go ahead. Oh, I understand that you're willing to plead guilty to the one count of simple battery. Is that correct?
Yes.
Okay. All right, state.
This is also a negotiated plea. The state is recommending 12 months with 30 days to serve, credit for time served, 15 days, balance probated with 6 weeks anger management. She also needs to comply with any MARTA suspensions in place. And the state understands that she doesn't know the victim. However, we want to make it clear that if she sees the victim, she needs to turn the other way. So there's a no further contact with Susan Morrow.
Okay. Is that your understanding, Mr. White?
Yes.
Okay. All right, I will take that plea now. Raise your right hand so I can swear you in, please. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. The first question I have is, are you presently under the influence of any medication, drugs, or alcohol at this time?
No, I'm not.
Are you satisfied with the service? Oh, I'm sorry. Yes.
Yes, sir.
Anything is not prescribed. How about that? What were you gonna say?
Yeah, you okay? You good?
Okay.
You put your hand down.
Are you satisfied? Okay. Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
And do you understand that you're waiving or giving up the right to trial by judge or jury, whichever you prefer?
Yes.
And do you understand that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes.
Are you prepared to agree to waive these rights today?
Yes.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
Yes.
Well, no, they haven't promised you that. And have they promised you anything to plead guilty?
No, they didn't.
Okay. Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
Yes.
And do you offer this guilty plea freely and voluntarily?
Yeah. Yes.
Understanding of the charges against you?
Yes.
And that's the charge of simple battery. How do you plead?
Guilty.
Okay. All right. And so they've explained the conditions to you. Do you have any questions? Because you have to do a 6-week anger management course, it looks like.
Yes.
And comply with any MARTA suspensions.
Yes.
All right. I don't have, do you all have anything else? Yes.
Ms. White, don't lean so far forward, we can't see.
Okay. Yes, sir. Yes, sir.
Thank you. Now be sure to get those 6 hours of classes out of the way as soon as you can.
Okay.
That'll be good for you. Thank you.
Thank you.
Yes. All right. Thank you. Good luck to you.
So can I ask a question? You know when I get out?
If you have nothing holding you, you'll be out tonight.
So, okay. Before tonight.
Oh, yes. You know, at 3 a.m., the temperatures start to drop.
It's gonna be cold tonight.
It's gonna be the freeze of a generation, I say.
Your Honor, did South Annex drop off the line?
Yeah, they did, didn't they?
Do we still have, I think we still have Aaliyah Brown.
27. Did you have 27?
No, I was going to inquire about position 2. I believe it's Aaliyah Brown.
Yes, I asked if we needed to bring position 2.
She needs to be brought.
She do? Okay.
She does.
Okay.
What about,
Thank
oh,
you.
I see, 1 was released, okay.
And I
Yes,
have
27 was released.
You have 27, 27 was released,
What about position 17?
and then 17. What's the name on 17?
Clifford Pearson.
Clifford Pearson.
Person, I'm sorry.
Person, she may not know.
I have a question about position 21. She was inquiring on how many hours she has to do for the anger management.
Let's see, 21.
8-week course.
That's an 8-week course, not necessarily hours, it's 8 weeks.
Okay,
So that's one course a week, which is 1 hour long every week for 8 weeks, for 8 consecutive weeks.
thank
Okay,
you.
thank
You're welcome.
And I'm going ahead to get position number 2 right now.
Thank you.
My concern about number 2 is that we're on public Zoom and this person is not an adult.
Well, that's what's been alleged. I mean, I don't have any objection to going to a breakout room, but
Let's do a
we have-
breakout room.
yeah, that's
Let's do a
fine.
breakout room before any face is shown on TV.
So still go get number 2 or?
Yes, please.
Okay, okay.
Judge, while y'all waiting on that position to come.
Position what?
Position 6, Kentrell Hall has a hit and run charge on his booking screen that was not on the case. And it doesn't look like we received an accusation for it.
Okay, I'm pulling it up right now, Mr. Jordan. Thank you.
Okay. And who's y'all need to break out room for?
South Annex when they come back. So South Annex, Judge Mincy and PD McLean.
Okay.
One on position 17.
As someone over at the other.
It's courtroom 2.
Did you have any information, Mr. Walker, on 17 at all?
I'm looking at position 6 right now, but I can.
Okay, after you
look
do
at
that
position
one.
17
Okay,
in just 2 seconds.
that's okay, no problem.
Okay.
Or you didn't have anything, did you, Mr. McLean?
I'm sorry, on number 6. I'm sorry.
17.
No, I don't have. Wait a minute. Oh, 17. I believe that is a conflict.
Yeah, Clifford Person.
Oh, no, I'm sorry. I was told that was a loan out. And sometimes they bring loan outs in the morning anyway, and sometimes they don't. So I didn't know if I'd expect to see him or not.
Okay, so he's going out. Okay.
We'll reset it 1 week.
Yeah, we'll reset him 1 week to 12/29.
Yes, ma'am.
Okay. Everybody get that? We'll reset 17 to 12/29. We'll reconcile.
The numbers on the card. Ms. Gant. The phone number that she, we had contact number, right, for his phone.
Once I get out, I got
Okay.
Is there another location for me to be in a breakout? I have a room full of inmates behind me.
That I don't know.
I'm ready. Yeah, I was just looking at.
Do you want to go over the calendar, Your Honor, since we just?
Yeah, we can go over the calendar if you want while they're bringing position 2.
What is it, Ms. Gant?
Yeah, this group of people is here to be interviewed on the phone for something else.
I think he wants to be in a quieter place. He's got a lot of background noise. I don't know, Mr. McLean, if they have any more room left for you to move around.
I don't need to go over the calendar. I'm straight on it.
Okay.
We're just holding on one position, so we can go ahead and go over the calendar, because after that, we'll be complete. I mean, he can mute if he want to.
Right, you can mute yourself, Mr. McLean, if you want.
Right, I just need another location for a breakout until these people are gone.
Okay.
Position number 1 is reset further notice, defendant release. Position number 2, we're holding. Position number 3 is going to be reset further notice. Position number 4 is also reset further notice. Position number 5 was a plea. Position number 6 was a plea, but we're holding on another charge. Position number 7 is reset further notice. Position number 8 is reset SAP 1229 for a social worker visit. Position number 9 was a plea. Position number 10 was reset further notice. Position number 11 was a plea. Position number 12 was reset further notice with a bond modification of an $8,000 split bond. Position number 13 is reset SAP 1229. Position number 14 was a plea. Position number 15 and 16 was plea. Position number 17 is reset SAP 1229. Position number 18 was a plea. 19 was a plea. 20 was a plea. 21, 22, 23, all pleas. 24, 25, 26, please. Position 27, reset further notice, defendant release. Position 28, 28, 29, and 30 were pleas. Any questions?
No, I don't, anyone out there? Mr. Walker, anything?
No, just wait on position 2.
Okay.
So instead of a literal breakout, or as part of a literal breakout that includes y'all, could I be on a telephone instead of a camera? And
Yes, I'll let you do that because I know you're in tight quarters there. Yes, you can dial back in.
as long as these people can't see, that'd be great.
Right. Well, we just have this last case. That's fine if the state doesn't have any major objections.
No objection from the state.
Mr. Jordan, is he saying that for tomorrow? No C for state court today or tomorrow?
I think it was referring to tomorrow.
Yeah, because I thought you guys had one today, right?
Yes, because I'm covering that.
Oh, you're doing everything today.
Apparently.
A long day. You're one of the ones working.
I guess so. Justice never sleeps.
There you go. 1224. Let's see. Right. Oh, you will conduct C on 1224 and 1226. Okay.
Yeah, I have C on 1224 as well.
Thank you for that clarification, Mr. Jordan. It's obviously not me.
Mr. Walker, we did get that hidden run acquisition. I'm looking at the case now. So it was an initiation error. So it should be a total of 5 charges on that case, not 4. So I'm pulling the charge on that.
And remind me, what did we do with position 6 again today?
It was a plea.
Oh, well, that changes things. um, so, Mr. Jordan.
Yes.
Would it be too late at this point to submit an NOD, I'm guessing? Or should I phrase, how should I phrase it? What's the easiest way to resolve it at this point, since it's a plea?
If you want to null process, that's fine, because we did receive the acquisition on it. Whoever initiated the case just didn't pull that charge into the case.
Okay.
It's
We
can do that.
There's a lot going on in here. If we saw position 6.
So there was an initiation error. We were missing the hit and run charge off of the case. We received an acquisition on it. But when the case was initiated, the hit and run charge was not pulled into the case. So it didn't show on the calendar.
Okay.
So we added the hit and run charge to the case, and the solicitor's office is going to submit a null process order for that charge.
Okay.
She's served 103. I mean, I typically wouldn't dismiss that charge, but because he has served 103 days, that's fine.
Okay.
Ron, do you know if PD McClain was able to call back in, if he's still on the line?
He said he was gonna call back in, but I don't see him yet. He's probably going somewhere where it's a little more quiet.
Okay.
Runner.
Yes.
This I think is in locating of Miss Brown, she's not here, but in the system it's saying that she's been transported, but it doesn't say to where. But she's a juvenile.
Oh.
Well, that's what we need to discuss. So
Yeah, she's not here though. She's not here at the South Annex.
She's not there. Okay.
can you stay on the line though, South Annex? Because I have a question to ask, but I would rather wait for PD McClain to be present.
Oh,
Yeah,
of course. I will.
yeah.
I will.
All right,
Okay,
thank you
hold
so
on a
much.
second. Yeah, he's going to call back in.
Okay, thank
No
you.
problem. You're welcome.
He's right there.
Oh, you see him now?
Yeah, standing up.
Oh, standing up. Mm-hmm. Oh, he is there. Mr. McClain?
Mr. McClain, do you just want to do the breakout room now? It looks like you have a
It
little
is
less
getting a
people
little more
present.
scarce here. It's getting a little more scarce. I could get on a phone with y'all, or I don't know. We're down to just 4 people left.
Yeah, they seem kind of quiet.
Are you okay with
For the
that?
moment.
They're doing fairly brief phone interviews here because these people are here for first appearance stuff.
Oh, uh-huh.
Because you don't have your phone.
No, I don't have my cell phone. I can get on one of these other phones. We can do a conference call.
Okay.
Okay.
What number?
Michael, what number?
What number should I give a conference call?
Let me ask Mr. Jordan.
2391. Okay, yeah, that's one digit different from what I'm used to saying. It's 2391. It's extension 2-2391, which is a 612 number, of course. 404-612-2391.
We'll be calling him on it.
Oh, that's a good question. Duh. Who's calling him? Or is he just calling into the link for the
I think that there's a number that you can call into the Zoom link.
Right, there's a
It
number.
should be on the invite.
Right.
I don't normally put it in there, right? Because.
Oh, you don't, Michael? Oh, yeah.
But it's 470-250-9358. And you have to put the meeting ID 960-2056-1400.
Now, what was the area code of that phone number? 470-250-9358. Put in 960-2056-1400. Do I need to pass?
Yes, and the password is 483-255.
Say again.
483.
Got it.
255.
Yep, got the whole thing. Thank you. I will call that right now.
Do you need South Annex to call the number as well?
No, the South Annex can stay on the screen, I believe, and then we can just all be. Mr. Jordan, you can put a telephone number into the breakout room. I'm assuming yes.
Yes, I can.
Okay.
Well, we shall see.
We shall see. I know.
We haven't done it, but I think you can. Okay, so on the line, so we can have the court, myself, of course, Mr. McLean, South Annex, and then ASG Dillingham.
Okay.
Listen to a breakout.
So is ACP done before y'all leave me by myself?
I think we're done this time.
I think we are.
Okay, well, y'all
have a good holiday.
All right, Merry
All right.
Christmas.
Take
Thank
care.
you.
All right.
Quick question, will this be a plea taken in the breakout room?
It will not eat. No, ma'am.
Oh, okay.
No.
Okay, thank you.
We just need your.
So, Mr. Jordan,
Yes,
do I go ahead and log off now?
you can. It won't be a plea. It was a juvenile case that shouldn't have been on the calendar anyway.
Okay, all right, thank you. Have a good Christmas.
You too. Thank you.